Today's topic came about from people that I was talking to on our last week's call. And, you know, I love the topic. Somebody mentioned it. They didn't even realize that they were giving me a great topic for today. But what I want to do is run through a couple of contract elements that we put in our purchase and sale agreement for my students, that they can use our contract. And within the contract are little what I could call escape clauses, ways to protect themselves in case things start to go wrong. They can get out of the deal. Some of these, I'll tell you, whenever you're involved in drafting a contract, you should always work with an attorney. I cannot represent you as your attorney, but I will be more than happy to speak to your attorney and work him through the process. But if you turn over a purchase and sale contract to a seller and you get it back and they haven't taken out some of these escape clauses, they're not reading the contract. And probably more importantly, they're not using counsel, because if I was working for a seller and I got this contract with some of these provisions, I would cross them right out. But hey, you don't ask, you don't get. Let's put them in there to protect you, to make sure you don't lose your earnest money, to make sure you don't get into a deal when you're not ready. One of the things I tell my students is that, I don't want your earnest money to go hard until you are absolutely sure you're going to buy this property. I one time worked with a student. I don't recommend this, but I worked with a student where we went on about 5 months and his money never went hard. At some point I kept telling him, I said, Bob, you got to just move on. This thing is not going to work out for you. No. I just need this. I I said, even when you get that, the deal's still not going to go through. Finally, he said, no, you're right. I'm done. And as soon as we killed the deal, he got his earnest money right back. No questions asked. I love it. But man, that's a tricky one. I don't recommend doing your business that way. It was bordering on, is he really acting in good faith? He was. I wouldn't want to go through that argument with a judge. Okay, so let's take a look at one of the first provisions that we put in our contracts that you can understand why it protects you. And this is Article 3, talking about the earnest money. Now, you're not going to see it in this paragraph right here. I'm going to tell you what I'm singling out in this paragraph, and you'll see how it manifests itself down the road as we get later on in this presentation. But the word here is effective, the effective date. So you only put your earnest money up X number of days after the effective date. Now, you might be thinking to yourself, okay, well, what's that big? Because you haven't seen my definition of effective date. If you think the effective date is when you sign the contract, no, that's the execution date. The effective date is defined later, and it's very important. So just keep in mind, as we go through this presentation, you're going to see how I define effective date. And I want you to remember this paragraph, that you only put your earnest money up after X number of days after the effective date. The thing is, I know that, during an inspection period, you can get your money back for any reason, right? But it doesn't matter to me. Anytime you move money out of your bank account and put it into someone else's bank account, your money is at risk. So I want to make sure you're protected, and that there's ways that you can get out of it for those reasons. But what I should preface this by saying is that what's transpired up to this point is the letter of intent. Maybe not. Maybe you decided not to go with the letter of intent. Maybe you decided to do, as the brokers call it, going straight to contract. No negotiation in the LOI, right straight to the PSA, and now you're going to do your negotiations. Here's the thing I want you to understand. If you agreed to something in the LOI, like let's say seller financing, and then you come to the purchase and sale agreement and you forget to take what you agreed to from the LOI and put it into here, guess what? It doesn't exist. It doesn't exist. Whatever you agreed to before must fall within the four corners of this contract, or it doesn't exist. Now, there are some exceptions. There's exceptions to every rule except for one, but just understand that it becomes very hard for you to get that seller financing back in after you've executed the purchase and sale contract and you guys are done negotiating. And I'll show you why before we end this this paragraph. All right, here we go. Now, check this out. And this is not a get out. This is not an escape clause. This is not a get out of free jail provision. I just want you to understand this. And this, I've seen this over and over and over again. This section 6.1 talks about essentially the due diligence materials. So if you wrote the letter of intent and you used mine, and there's a schedule 1 in the LOI, and it lists all the things you need for the due diligence, and you and the seller have edited it, you put things in, you took things out, and you are ready to go to contract, that Article 1 or Schedule 1 in the LOI should be cut and pasted right into this Section 6.01. And the problems I see are when you get an executed LOI, okay? You get an executed LOI, and there's not one mark on that Schedule 1. The guy didn't even look at it. And then you come to the Section 6.01, where you just cut and pasted everything that the guy had agreed to in the LOI. And now, oh, how dare you ask me for all these things? No, pal. In the very first correspondence I ever had with you, we put all of this information in. You had your opportunity to say up or down, and you sat on your hands, and now we're looking to put it into purchase and sale. All right. That happens. You got to negotiate it. You got to work to get to that bottom line, because remember, this contract, this is the contract. This is what everybody agrees to. The LOI was a great start, but if he says, no, I don't agree with this, then you're going to have this problem. Okay, so here's the issue. This particular provision, that happens to be the last bullet point on most of our Schedule 1s. We're looking for 12 months of bank statements. That's it. Don't tell me you don't have it. Don't tell me you don't work with a bank. You do. And so in this document, we want you to turn over 12 months because we want to see the money. Listen, guys, well, I run some personal expenses through that. I don't care. Well, I have multiple properties, so I merge them all together. Yeah, that's baloney. You know why? Because your accountant, if this property is owned in an LLC, your accountant is going to file a K1 for this property, and he's going to go out there and figure out what deposits were for which property. So don't give me that line that you throw everything together. I want to see the bank statements, and here's why. That is where we start our financial forensic accounting. We have to find a starting point where we have a third-party document verifying the information, and nothing's better than a bank statement. And I don't care about the checks you wrote out on that bank account. I'll get to that later. The thing I'm most concerned with is the money coming in. I can control the money going out when I own the company, but the money coming in, that gives me a picture of what your business is like. And that's the thing is, can you imagine going to buy some franchise and they don't let you see the financials? They don't let you see the bank statement? That would be a criminal. You would never spend money on another company that didn't turn over their financials. Why is it any different than multifamily? It isn't. You're buying a business. You need to verify the revenue that comes into that business over the last 12-month period. So this particular provision always gets kicked out when you're dealing with some, mom and pop shop. Don't let it. make sure that you get this information, or you have no other place to start from. Oh, that water's good. Oh, that water's good. Here we go. Now, here are a couple of very interesting provisions that have come about over time. Let's talk about these. These happen to fall into the seller covenants. Seller covenants basically tell where the seller is saying, this is what I do. I promise this, and I guarantee that the property will behave in this particular way. So take a look at these. First one, letter K, is the seller should a change in occupancy occur which is greater than 5% during the course of this agreement. Seller shall notify the buyer immediately, in which event the buyer shall have the option to terminate this agreement and receive a return of the earnest money. Let's stop right there. Here's the thing. First off, the bank is going to want to know if there's been any variance in the occupancy. But look at this particular provision. At what point in the 90-day window that you have this property locked up under contract, at what point can you get your earnest money back? Oh, the inspection period. Okay, but that happened 45 days ago. We're past that. Okay, well, during the financing period, well, that was 60 days. We're past that. We got 2 weeks to go before closing. And guess what? Your money is hard. But what happens if the occupancy switches by 5%? Can you get your earnest money back? According to this paragraph, yes, you can. Seller agreed to it. So that's the first escape clause we put in there. And if the property swings by 5%, you can walk and get your money back. It says it right there. All right, let's take a look at the next sentence. At no time shall security deposits be applied to rent or any other fees or charges due from the resident. Okay? Why would that be in there? Well, let me tell you the story. All of these have stories attached to them. I was representing a client, and we drafted the purchase and sale agreement just like a typical statement. It was discussions about what happens to the security deposits. When they switch over, it was all in the contract, and we had this wording in there. And so what happened with this wording was the seller didn't have the money. It was about $7,000 in security deposits, and he didn't want to pay it back because he had spent it already. So he didn't want it coming out of the closing proceeds. He just wanted to say, hey, it's gone. So what he did, and this guy was a lawyer, what he did was drafted a document and went around to all of the tenants who had delinquent rents and said, I'll make a deal with you. You waive the security deposit, and I'll waive the delinquent rents. And you've got a new owner coming in, you're starting from scratch. You owe him nothing. What C-class resident wouldn't sign that? He had a stack of them when he was at the closing. He says, nope, I don't owe you any security deposits because the people have waived their security deposits in lieu of delinquent rents. And I'm sitting back there like, oh, come on, man. Come on, man. And I was on the phone with my client, who's one of my students. And he said, I call him, I said, hey, what do you want to do? And he goes, I said, the guy's wrong. He owes us this money. Do you want me to just handle it? He goes, yeah, could you just handle it? I don't even want to deal with this guy. I said, okay, fine. So I called the guy back, and they were at the title office. They're sitting around. We're trying to get this thing closed. And this guy says, okay, what do we, let's move on. We got this problem with the $7,000 for the security deposit. I said, yeah, that is a problem, but we're not going to accept that. And you're going to owe us the $7,000. No, I got all these people have signed off, these estoppels. I think he called them estoppels. And we're not going to owe that money anymore. I said, you can't use security deposits to pay back delinquent rents. He goes, sure I can. I said, no, you've already agreed to that in the contract. Show me where in the contract it says that. Okay, now I wrote the contract, so I knew exactly where it was in the contract. But this is one of those times when you just want to take the benefit of what we call pregnant pauses. And I just sat there and made it sound like I'm flipping through papers. And finally, I get right there, section 7.01, letter K, paragraph K. And I just shut up. And the guy read it. And he goes, okay. All right, so we'll pay you the $7,000. Thank you very much. So we got the money, but that's why that provision is in there. Otherwise, the guy would be doing that. You know, I had one property, I had about $24,000 in security deposits, and I spent it. And I could. It was a Michigan property, and in Michigan, you can use the security deposits to run the business as long as you bond it. So for $500 a year, I would buy a bond, send it to the district attorney or district attorney general, whoever it was in Michigan, and let them know that I bonded the security deposits and I will pay them. I will refund people at closing. I mean, at closing time, I had to come up with that money and put it on the ledger to the seller, to the buyer. But during the course of my ownership, I just used the security deposits. They went right into my bottom line. I ultimately owned them. They showed up as a liability, but I could use the money. All right, next paragraph. And obviously no lease shall be executed without a fully completed and signed application, credit report, and no concessions will be given out, okay? So we don't want them to give away any of the rent charges or, and we want to make sure that all the tenants are good tenants. They're not just trying to load people up. Because remember, we just said, hey, if your occupancy drops by 5%, or we get to get out of this deal. We don't want them coming back and starting to throw all these sex offenders in there looking for a place to live. All right, now this next paragraph has been written two different ways. This is the way you're going to read it right now is one particular way. All appliances, fixtures, and equipment related to plumbing, heating, and cooling, electrical systems, and any other equipment or systems shall be in normal working order at closing, ordinary wear and tear accepted. No fixtures or appliances shall be removed from the property after the effective date herein without notice to the buyer. All units shall be in rent-ready condition. Folks, follow me on this one. Shall be in rent-ready condition at the time of closing unless otherwise specified or unless vacated within 48 hours prior to closing. Any units vacated within 80 hours prior to closing shall be reported to buyer prior to closing in sufficient time to allow a final inspection of the vacated units by the buyer. All said vacated units shall be in rentable condition with the exception of normal cleaning requirements or appropriate adjustments shall be made to place the units in a rentable condition. The only thing that's missing from here is a dollar amount, okay? Because sometimes you can do a dollar amount, say like any units that don't meet these requirements, the buyer will be credited $1,500 at closing. All right, this is why we write the purchase and sale agreement, and I left this particular paragraph out, that you can inspect the property at any time during the length of this contract with 48 or 24 hours notice. So the inspection period is over, but you can still go in and inspect. The inspection period may be 30 days that you can't get your money back. But beyond the 30 days, you can still inspect, and you write the contract so that you can always do that, because before closing, you want to walk all the units again. Because during that 90-day window, these folks haven't done a thing. They're not leasing up. They're not turning the units. They are not running this the way you're going to run it. And so what ends up happening is when we took over a property, we thought we were getting like 96% occupied. It was 50% occupied. And we went around like, where are all these people? The units hadn't been trashed out. They hadn't been turned. They weren't rent ready. We got a huge problem on our hands. And that is why you want to make sure 48 hours before you close, you go around and you can tell if someone no longer lives there. And say, hey, this guy's showing up on the rent roll as being occupied. There's nobody here. Oh, he must have just skipped. Oh, yeah. 14 units and they just skipped in the last 48 hours? I don't believe it. These guys have been gone for weeks. You have not updated the rent roll. These people are not paying, and I'm about to find out 30 days from now when you're long since gone. No siree. These units have to be rent ready in rent ready shape, or you're paying me, or we're not doing this deal. And I'm telling you why we're not doing this deal, because this rent roll is not 95% occupied. This rent roll is 72% occupied. And check out paragraph K. I'm taking my money back and I'm walking. Oh, wait. Okay. Are you seeing how it all is coming together? I'm trying to protect my students every way I possibly can. I don't want this to happen to you. How do you know that this stuff goes on? Why do you think I'm an expert at it? Because I've learned the hard way. All right, let me keep on moving here. All right, so inspection and financing period. Now, what I want you to do here is just follow the wording here. Okay, so let's take a look at the first bullet point. Commencing upon receipt of all, so in writing before the expiration of 30 calendar day period, which commences upon the receipt of all documents and requirements detailed in section 6.01, the effective date. Okay, remember, execution date, effective date. When is the effective date? The effective date is when all the documents in schedule 6.01 have been received. If the guy doesn't give you any of the documents or he leaves some out, the effective date has not been satisfied. It does not exist. You don't have to get your earnest money in. And the reason why we do this is because, hey, you're being asked to move money out of your bank account into someone else's bank account, and the seller hasn't even lifted a finger to give you what you need to buy the property. So why should you have to put your money at risk if this guy's not even working for you? So this effective date doesn't start until you get all the documents. And once you do, when you've got a checklist, you check them all off. I certify that today is the effective date. I owe you my earnest money deposit 7 days from today. We signed the contract 2 months ago. That's the execution date. And this guy has still been sitting on his hands. It happens, folks. It happens. If this guy's not going to help you get this thing sold, why should you put your money at risk? So that's the difference between the execution date and the effective date. When's the effective date? What day of the month? It doesn't, no one knows. And here's the problem. Brokers get ticked off at this. And sellers are like, what? Wait a minute. You haven't put in your earnest money? I said, wait a minute. I told you, even in the letter of intent, we explain it this way. So they know from day one how this works. And they're like, well, you haven't put in your earnest money deposit yet. Why should I be doing this? No. The effective date for this contract could have been on the same day as the execution date if you had given me all the documents. But you're sitting there dragging your feet. So why should I help you? Get out there, get me your documents, and then I'll pay you the earnest money. And so that's what you tell the brokers. That, well, this definition is not going to work. Oh, why? He can't give me the information? Well, he's got to go put it together. I know, we're not under contract yet. I've been asking for all the same documents since the very first piece of paper I ever sent you folks. He knows what I'm looking for. Have him go get it. Well, I'm not writing a check. So that's how we write the effective date and protect the students to make sure they get what they need and they're not going to be jerked around by some seller who doesn't have what they need. And this section 8.03, folks, one of my students stuck this in there. I liked it and I kept it for our contract. But look at the way this is worded. After the expiration of the financing period, so you've been through the inspection period, now you've done the financing period, as set forth in 8.04 and 8.05, if the property does not appraise for at least the purchase price, this agreement shall be considered null at your option and void upon your written notice to the seller from the appraiser. At such time, any earnest money being held by the escrow agent shall be immediately returned to the buyer, and neither party shall have any further rights or liabilities hereunder except for those provisions which expressly survive the termination of this agreement. So can I get my money back after the financing period? Yeah, if it doesn't appraise. If it didn't comp out, you can say, all right, I'm out. Now, that is just another escape valve for you. You'd have to go out and get an appraisal. But you know what? If you've got $100,000 hard and the deal is going south and the property is, having trouble, get an appraisal. Hire somebody to go out and do an appraisal, pay the money, or you're going to lose your earnest money deposit. It's just another escape for you. And then what we also put in there is a financing extension period. Look at this. If financing constraints dictate the need for additional time, an additional 30-day extension period shall be available upon written notice from the buyer to the seller. Such notice shall be made prior to the end of the financing period. Folks, two things are missing in this. Any consideration for that additional period, you're not putting up any more money. And the second thing is that all it takes is you giving them notice. You don't even have to get their permission. You can just say, hey, you know what? We're having trouble with the financing. Really? I thought you already got approved by the bank. Yeah, we did, but they set the LTV at 75% LTV, which requires us to raise 25%. We haven't finished raising the money yet. We have a financing issue. That's a financing constraint. Okay, so you get another 30 days to go out and raise the rest of the money that you need. And you put that wording in there and you're like, okay, that's pretty good. Didn't cost me anything. And I get it automatically. I just have to let them know. That's another thing you put in there to protect yourself. All right. Okay. This one is these. I want everybody to understand how this works. So you probably see these provisions in the contracts, and you might not understand why they're there. But more importantly is because you are the quarterback of this deal and you are in charge of the whole deal, you had better understand what every paragraph means. And I teach all my students exactly everything about the purchase and sale agreement so they know what's going on. So let me talk about these two particular provisions. Memorandum of contract. Buyer may prepare and record a memorandum of this agreement at its sole cost, and seller will sign the same. Okay, remember, I'm the buyer. Seller, in this provision, is going to allow me to do this. Now, you might be thinking to yourself, what the heck? What does this mean? Okay, in those states where there's they're non-disclosure states, and you don't want people to know how much you're paying or what your mortgage is, what you do in those states at the registry is you don't record the mortgage or you don't record the deed. What you do is record a memorandum of deed or a memorandum of mortgage. And it's a one-page document letting the world know that there's a mortgage on this property. And that's all we're going to tell you. We're not going to tell you how much it is, but we're going to tell you one exists. So anytime you have an interest in land, you can go down to the registry and record that interest in land. And in this particular case, when you sign a purchase and sale agreement, you are creating an interest in land that can be recorded at the registry. And so you want the whole world to be on notice that this property is under contract and we have it under contract. But you don't give all the details about this contract because that would disclose the price and everything else. But you record a memorandum of purchase and sale and you record it down at the registry. It clouds the title. The seller can't turn around and sell it to somebody else because you've just told the world, I have rights on that property. Now, if you don't release that memorandum, there's going to be a problem because this guy can't sell his property until you do. That's why a seller hates this paragraph and won't allow it. If they have an attorney, their attorney is going to wipe that out. They don't want that. No. If this purchase and sale doesn't go through, you're not clouding our title. But that's why you see it. And that's why you see it in our contract as the buyer. You have the right to do it. Doesn't mean you are going to do it. But if you start getting into a peeing contest with the seller, you can go and cloud the title by recording a memorandum of contract. Okay? That's what that provision means. Now, this next provision is typical legal, miscellaneous wording in a legal contract. It's also called the merger clause. And the merger clause states that everything we've ever discussed about this deal, in any parole evidence, any oral evidence, any written documentation, has all been written and brought and memorialized into this agreement. It all merges into this agreement. This is called the merger clause. And remember how I said before, if that letter of intent was talked about seller financing and it doesn't make it into this, it's out. This paragraph kicks it out and says, no. You may have agreed in the letter of intent. That letter of intent is gone. It does not exist anymore. Don't even bring it into court under certain exceptions. But we are just looking at this contract, and there is no mention of seller financing in this contract. So I don't know why you're bringing it up. All because of this particular provision. It's called a merger clause. All right, next. Oh, boys, this is where we finally get down to defining the effective date and the execution date. So when you're reading the contract and you're looking at what happens on the effective date, what happens on the execution date, the seller will think that you've just misspoken, that you've said, oh, what they mean is the execution date. Oh, the effective date is really the same date we sign everything. Oh, no. If you go back and look in the paragraphs where we use the word execution and we use the word effective, those are the dates where we always, that are clearly defined back in the miscellaneous section. As you can see, for the effective date, the performance of various obligations under the agreement, the effective date of this agreement shall be the date the seller has provided the buyer with all the seller submission materials in Article 6, period. Execution date is when all the parties have signed it, or in whole or in counterpart, and it's received by the escrow agent. Okay, that's where we get the effective date and the execution date differences. Okay. Oh, and then of course, folks, just so you understand, after COVID, all purchase and sale contracts have a force majeure or a material adverse effect provision in there. These things are now appearing in all contracts because of COVID, but that is really I just put this in there just for your benefit. So that is it.